Okay, we're going to be finishing up our discussion on journalists and the law today. Now, I'll go ahead and tell you this is a pretty long video, so you may want to take it in two parts. You may want to watch about half of it in one sitting and the other half in the other sitting. It's about 24 minutes and change. But as I mentioned at the end of the video, I think all of these issues when it comes to journalism and the law, I think they're all really important for us to be introduced to in this course. So that's why I've gone a bit longer on this video. But again, take it in chunks, and as always, let me know if you have questions, and we'll be talking to you soon. Okay, in this video lecture, we're going to be continuing on with our discussion of journalists and the law and looking at further some of the protections and the pitfalls and some of the gray area that comes up when we're talking about where the legal lines are drawn when it comes to journalism. We'll start off by looking at the Freedom of Information Act, or what's sometimes just called FOIA. This was instituted in 1966, and it was intended to open records and files for public inspection to the fullest extent possible. There's about 600,000 FOIA requests made every year, but the idea here is that we want the federal government to be transparent about the records that it keeps in conducting public business. As digital media has become more and more important in terms of storing records, in 1996, Congress passed the Electronic Freedom of Information Act, which expanded FOIA to encompass electronic records as well, and it also required electronic reading rooms to make records more available to the public. For example, in most government offices, including local government offices, there are dedicated terminals where the public can come in and review the different emails that are sent by public officials or public employees in the course of doing their work. Now, of course, if someone who works for the government uses a personal email for business purposes, then the water gets quite a bit muddier, and we've seen some recent news about that in the issue of Hillary Clinton and her use of a personal email address, a personal email server even that she kept at her home to conduct business with the State Department when she was Secretary of State. But when correspondence is conducted using public email addresses, official government email addresses, oftentimes you'll find dedicated terminals in government buildings so that the public can come in and review those emails. Now, there are some exemptions to the Freedom of Information Act, some criteria that would allow for government documents not to be made available to the public. These include issues regarding national security, housekeeping material, so like internal operations documents, any material that's exempted by statute, trade secrets, for example, patents that might be under review, or any trade secrets if government is doing business with say a private commercial venture, and any trade secrets that might be a part of that are protected. Working papers or lawyer-client materials are protected. Any sort of personal privacy files, law enforcement records, financial institution materials, so materials that come from the Federal Reserve or FDIC are protected. Also geological data, so that in the marketplace there's a fair competition among people who might, say, want to buy land for mining purposes or something like that. It would be unfair if they got a hold of geological data that gave them an upper hand or an advantage in those dealings. So geological data is also protected from FOIA disclosure. Now, there are also federal laws guiding open meetings when government is conducting business as well. So in 1976, there was the Government and Sunshine Act. This is a federal law that applies to open meetings. So unless there is some sort of criteria that would exempt a meeting from being open to the public, then this law says that it should be open to the public. This applies to boards, commissions, and agencies appointed by the president. It does not, however, apply to congressional bodies or boards and agencies serving only as advisories. So this is specific to boards, commissions, and agencies appointed by the president. At the state level, all states have some sort of open meetings and open records laws. Also, this follows the same principles of government in the sunshine, right? We want public scrutiny for the operations of those that are elected to power or whose salaries are paid by public tax dollars. But details vary from one state to another in terms of what meetings and what records are or are not open to the public. Moving to look at the protections of journalists in terms of revealing their sources, the landmark case on this issue was the Brandsburg v. Hayes case in 1972. Here again we see a 5-4 decision, so this was a split decision, very close, only passed by one vote, or the majority decision was only passed by one vote. But in this case, it said that the First Amendment provides no special protection for journalists, specifically when they are called before the court and required to testify or to hand over information that might be subpoenaed from them. This comes up often in the use of anonymous sources in stories. There have been a number of cases where journalists have used anonymous sources and the information that they received perhaps violated some sort of law or displeased the government in some way, suggested a leak of classified information, and these journalists are called to testify as to who their source was. And oftentimes journalists, to maintain their credibility when they've promised confidentiality to a source, they keep that promise, and they have gone to jail for contempt of court for not revealing those sources. So the Brandsburg decision said that that there is no protection for journalists in these cases, that they essentially appear before a court just as any other ordinary citizen would. Again, however, this was a split decision, and in the dissent, the court said that the government first must have probable cause to believe that the reporter has information relevant to a specific violation of law. Secondly, it said that the government must be unable to obtain the same information by alternative means less destructive to the First Amendment. And lastly, that the government must have a compelling and overriding interest in the information. So this was intended to give some legal guidance and precedent to the idea that government agencies, government officials should not be able to indiscriminately, wantonly, and recklessly just go about demanding information from journalists, because that would hinder their ability to perform this responsibility that they have in our society to be watchdogs and to get truth out to the public, again, to provide citizens with the information they need to be free and self-governing. So that is the law of the land on the federal level in terms of Supreme Court precedent. However, at the state level, many states have enacted shield laws, which essentially does provide journalists with protections from having to testify or turn over information that they might be required to turn over or reveal by subpoena. However, because there's no federal shield law, and this is a matter that's debated even among journalists whether or not it would be a good thing to have a federal shield law, and there are certainly benefits and also perhaps dangers to having a federal shield law. For example, who gets to define who is a journalist, right? Particularly in today's online world, having some governmental agency licensing or sanctioning certain people as journalists protected by a shield law and others not protected could be a dangerous thing. But at the same time, perhaps providing some special acknowledgement of the role of journalists to get accurate information out there, information that sometimes could be risky for a source to disclose, might argue in favor of having a national shield law. But there are, again, state shield laws, but they vary from one state to the next. So there's a great deal of difference in terms of how journalists might be protected in one state versus another. Some states have no shield law. Some states have a absolute privilege for sources, and some states have limited privileges for sources. All right, so let's move on and talk about libel. Libel is a type of defamation, defaming someone's character or good name. Another type of defamation is slander. The main difference here is that libel must be published or in some sort of written form, whereas slander generally refers to defamation that is spoken and not written. In order to win a libel case, a plaintiff must prove first publication, again, so that we understand that this falls under the considerations of libel and not slander or some other kind of defamation, that the individual was identified, so you can't libel someone if you haven't actually identified who they are. It has to be proven to be defamatory, right? So you know, if you say someone is a wonderful citizen, you're going to have a hard time proving libel if they're talking about you. That's not defamatory. So a plaintiff has to prove defamation. They have to prove falsity, so just because you don't like something being said about you doesn't mean that it's libelous. If it's true, it's not libel. It's just maybe something that you don't want getting out in the public, and there's a big difference. There's also a certain level of fault that a plaintiff has to prove depending on what position they hold in society, and I'll go over that here in a moment. But the suit also has to be brought before the statute of limitation expires. Okay, so talking about different levels of proof that are required. If you are a private person and you believe you have been libeled in a publication, you are not in the public spotlight in any way, then you only have to prove negligence, which is defined as a failure by a publication or an individual to exercise reasonable care. Right, so this is a lower standard, a lower burden of proof that a private person has to meet in order to successfully sue for libel. If, however, you are a public official or a public figure, you have to prove actual malice. Actual malice is defined as knowledge of falsity or reckless disregard for the truth. So someone publishing information that's defamatory has to know that it's false when they do it, or they have to demonstrate a complete reckless disregard for the truth, that they really should have been more careful, and that it wasn't just that they failed to exercise reasonable care, but that they had this language that the court uses to say reckless disregard for the truth. Now, the law also parses out a bit more what we mean by public officials and public figures. So public officials are straightforward, those that work for government in a position of authority, which invites special scrutiny, right? So we might think of the mayor or a city councilman, a county commissioner. These would all be examples of public officials. Then we have all-purpose public figures. These people occupy persuasive power and influence, and they're usually exposed to constant media attention. So many of the celebrities out there, think Oprah Winfrey or John Stewart, right? These people would be considered all-purpose public figures. They have a position of strong power and influence, and they're no strangers to media attention. However, we also have what's called limited-purpose public figures, and this occurs when someone voluntarily injects themselves into a specific public controversy using media. So, if there's a libel suit that a plaintiff brings forward about some news article, let's say on an individual's involvement in protests on immigration law or something like that, right? And if the plaintiff, if the person that's suing for libel has voluntarily injected themselves into this community conversation, right? This public controversy. If, let's say, the plaintiff is a protest organizer, right? They have then voluntarily submitted themselves to a higher level of scrutiny by positioning themselves in this very public position for this specific cause. Now, however, if this plaintiff was a protest organizer for immigration concerns, immigration law, but there was an article written about this person that referred to their driving habits or something, right? Something that was entirely unrelated to immigration. Then in that case, they would not hold the position of being a public figure for those purposes. So this is what we call a limited purpose public figure, someone who voluntarily injects themselves into this public controversy and invites increased scrutiny. Now, I've had students ask me before about satire. Does that count as defamation? It's clearly false, right? And a lot of times we're making fun of people. So if you think about The Onion, if you read The Onion, I believe they once called Kim Jong-un the sexiest man alive. This was total satire, but it was about a real person. Now, whether or not we could qualify that as being knowingly false or not, I guess is up for debate. But certainly there are other items that we recognize as patently false, but they're expressed in a humorous or satirical manner. And so the Reporters Committee on Freedom of the Press says that although these satirical statements may be offensive and intentionally injurious, they contain constitutionally protected ideas and opinions, provided that the reasonable reader would not mistake the statements as describing actual facts. So the idea here is that, hey, everybody knows this is a joke. Sorry you got your feelings hurt. I'm sorry if you were offended, right? But this type of speech is constitutionally protected because nobody really is going to believe whatever is being said in this satirical piece. Everybody recognizes that it's a joke. Now, a close cousin to defamation is the invasion of privacy. And these generally fall into four categories. You can have the appropriation of a name or likeness for trade purposes. And this doesn't deal with journalism so much as it does advertising. So if someone used a picture of you without your consent to sell shoes, right, then that could be an invasion of privacy. And that's actually fairly close even to discussions of copyright law. But it's one of the categories that is addressed in invasion of privacy. But more relevant to the daily work of a journalist is the intrusion upon an individual's solitude, the publication of private information about an individual, and then publishing material that puts an individual in a false light. And I'll discuss that a little bit more, clarify that here in just a moment. But intrusion upon someone's solitude. So this is basically people being where you don't want them to be, invading your privacy in a physical way, right? This generally occurs in the process of gathering information. So if a reporter violates the law and sneaks into your house and takes pictures of you while you are in some compromising position, right? Or you're in your underwear, right? And somebody comes in and takes pictures of you. That's not okay. You're protected by law. And the question is, does the person enjoy a reasonable expectation of privacy when the information is collected? If you're in your house, laying around in your boxers or whatever, right? You don't expect people to be coming in and taking pictures of you. On the other hand, if you walk out your front door in your boxers, now you're in public, and there is no expectation of privacy when you are in public. The next category of invasion of privacy law is the publishing of private information. First criterion here is that it has to be highly offensive to a reasonable person, right? If someone publishes that I was wearing blue shoes yesterday, that's not going to be highly offensive to a reasonable person, right? So we wouldn't really consider that private information. We have to prove that there's no legitimate public concern or interest here. So even if it's highly offensive to a reasonable person, if there is a legitimate overriding public concern or interest, it could justify the publication of that information. So for example, a woman who had her dress fly over her head at a state fair and had a picture taken of her was won a case in which she had sued for publishing private information because there was no overriding public concern or interest to that information or that picture. However, an 18-year-old who was sterilized at a county juvenile home and was identified and sued for an invasion of privacy did not win because the court suggested and held that there was some sort of legitimate public concern or interest in that story that overrode the personal privacy rights of the individual. However, some information may not be private by legal standards, but it's important for journalists to understand that that doesn't necessarily mean that that information is appropriate for publication. And for example, rape victims of sexual assault, are generally not identified in news stories, even though there's no law that says that journalists and news organizations cannot identify victims of sexual assault. It's generally considered inappropriate to do so, that it doesn't really serve the public good or understanding among readers to identify those victims. Okay, lastly, when it comes to invasion of privacy, we have what's called false light. And this is where the material itself is not necessarily untrue, right? But that it's presented in a way that misleads the reader and presents the subject in a false light, right? And so the first criterion here is that the information or the publication has to be highly offensive to a reasonable person, right? Similar to the publication of private information. The publisher of the material has to be proven as being at fault. And you'll often see this occur when news organizations use photos of people that are unrelated to a specific story. There was a case where a Baywatch actor had done an interview for Playgirl magazine, but had not actually stripped down to the buff, but was presented on the cover alongside a teaser headline that said 12 sizzling centerfolds. And so that would make a reasonable person perhaps conclude that this Baywatch actor would be seen naked in the inside pages of this magazine, when in fact he wasn't. So this was a case where Playgirl magazine was found liable for invading this individual's privacy by way of presenting him in a false light. So I know we covered a lot of material in this video relating to journalists and the law, but these are all really important legal considerations when we talk about the field of journalism. So I really think it's important that we go over them here. But as with the history of journalism, right? I mean, or really any of the things that we've discussed in this semester, there is so much more out there that we could get into. But hopefully this gives us a overview of the main points that are of interest when it comes to journalists and the law.